Hi everyone, thanks for joining us today for our webinar on preventing wage underpayment in your business. By way of introduction, my name is James True. I'm the practice leader in the Legal Vision's employment team, and I'm joined here by Joel Hayden. He's a senior lawyer in my team. The things we're going to talk about today is how to prevent underpayment in your business, and this is an increasingly, I suppose, hot topic. We're seeing lots and lots of media coverage on this issue, and it's also an increasingly common issue for businesses. It's something that businesses now also need to, I suppose, give a lot of attention to. Because the numbers we're seeing for underpayments are increasingly larger. So the risk to businesses these days is, number one, actually accounting for the actual underpayment. So it is almost always a liability that hasn't been accounted for and is a real sting to the finances of the business. And then number two is actually the exposure to penalties. So increasingly in the regulatory framework, we are seeing that the Fair Work Ombudsman does not want to go easy on businesses who have underpaid their employees. So there's significant exposure to penalties. We are seeing penalties in the millions, whereas historically they may have been much less or more akin to a slap on the wrist. They're penalties for the business, for the company, but also for the individuals who might be involved in these breaches. So you can be personally liable yourself for a penalty under the Fair Work Act. The other key sort of issue is reputational damage. And that comes in two forms. You have your internal reputational damage in terms of what all your employees think of you as a business, and a lot of the trust and confidence that might be lost when you have an underpayment issue. You also have your external reputational damage. As I said, these are increasingly the types of things that are being reported in the media. They do make the papers now. And so that's something that your brand actually needs to deal with. So we're going to talk about how you actually prevent it. We're also going to cover things like what to do if you've got one, and how you can manage it. So there's the agenda there. Well, Joel is going to start us off talking about key employment entitlements. So that's really what are the types of things that create the underpayment. So what hasn't been paid that means there is an underpayment. I'll talk us through some common causes. So how does this actually happen? Number three, we'll go back to Joel, how to conduct a wage audit. So that's really, okay, well, can I check in my business whether I'm actually carrying these types of liabilities? So do you get on the front foot and proactively look for this so you can manage it and know it's there? Or also conducting wage audits when someone's put you on notice that there's an issue in your business. So that could be an employee claim or just a general concern. And then finally, we'll come back to me. I'll talk about what we actually do if you've identified that there is one. So the process and strategy for fixing it and moving forward to give you the best chance with the Fair Work Ombudsman so that you're not being penalised too heavily. Please do send through your questions. While we're talking, we'll try and get to as many as we can at the end. And you can see the final point there is a special offer for the webinar attendees. I'll talk you through that at the end. But if we don't get to your question today, we will also have an opportunity for you guys to book in directly with us and we can have a conversation another time. So enough from me. I'm going to hand over to you, Joel, to talk about key employee entitlements.
Thanks, James. And as I'm sure everyone here has at least a general understanding of, there are a number of legal sources of employee entitlements in the Australian workplace system. And with many potentially overlapping obligations, it is a complex system. And that's probably why everyone has logged on today to watch this webinar. And look, at a high level, and as you can see on the slides here, some of the most common sources of legal obligations that may create entitlements for employees in descending hierarchy are the Fair Work Act itself, any applicable modern award, any applicable enterprise agreement, and then an individual contract of employment as it applies to individual employees. And without going into too much legal depth on this point, each of these four items can result in legal obligations on an employer with each source higher up the chain providing a minimum entitlement to an employee that may be modified by the lower sources, but generally can't be undercut. And to briefly outline some of the entitlements that apply pursuant to the sources on the slide, the Fair Work Act, we've all heard of it. It sets the framework for things like the national minimum wage, but also creates other entitlements under the National Employment Standards and its other provisions, including things like annual leave, personal leave, as well as redundancy and notice payments. Modern awards, which I'm sure we're all familiar with on some level, and of which there are 122 which apply to a large majority of employees in Australia on both an industry and occupational basis, cover employees and employers as a matter of law, and create minimum entitlements for employees, including wages, penalties, loadings, allowances, that type of thing. And honestly, I'm sure James will agree with me on this. And it seems like a lot of the complexity in the Australian system is concentrated on modern awards, and that's where we often see most underpayment issues pop up.
I'll jump in there, Joel. How does an employer know if they're covered by an award?
Often by getting some legal advice, because as I said, there's about 122 that apply, and really it's not up to an employee or an employer to decide what award covers. It applies as a matter of law. So really you have to either look into this quite carefully yourself, identify the industry you're operating in, whether your employees are classified within that industry award, and if they're not, boil down to the occupational awards that may apply. If they don't apply, it might be the miscellaneous award, and if that doesn't apply, then they're probably an award-free employee. So you can see there's a lot of complexity in even getting to the point of determining which modern award does apply to your business. And then
what's the consequence of an award applying? So you determine that an award does apply. What does it actually mean for an employer if there is an award applying in relation to their employees or their business?
Yeah, so what that will mean is that the employer is bound by the minimum entitlements that are contained within that award. And if you don't comply with those minimum entitlements, there will be a breach of the award, and that amounts to a breach of the Fair Work Act and links back into what James was talking about a little bit earlier in the introduction, which is where there's a breach of an award, it's a breach of the Act, penalties can flow from that, and the Ombudsman can prosecute that, and individual employees can also pursue their rights under the Act. So very complicated, very risky part of the employment system in Australia. And then again, moving down those sources on that slide, we've got enterprise agreements coming in next. And they're collective agreements which are negotiated with employees or their representatives, which is a union effectively, and then registered with the Fair Work Commission. And these will apply to a group of employees, and it's required to make an employee better off overall than the relevant award that would have applied to that employee, and often provide increased entitlements to that underpinning modern award, which will apply and are binding in the same way that an award is binding. And then a further layer under that is, like I mentioned a bit earlier, the contract of employment, and this will just apply to individual employees, and again may create legally binding entitlements for an employee. And often it will be things in excess of entitlements at law, such as salaries, overtime, loadings, etc. But there's also often contractual terms like bonuses, commissions, profit share, car allowances that can be the basis of an underpayment. And while these four items are the most common examples of legal sources of entitlements, there are, of course, other sources as well. And this can include things like individual flexibility agreements, long service leave legislation, state to state. There are also some state awards in the public system, or some copied state awards that may still apply, but we won't go too far into that because that's quite complicated as well. But the bottom line is that there is a variety of sources of employment entitlements in Australia. Each level creates the possibility that an underpayment may occur, and it is a difficult system to navigate. Now that we've addressed really what the most common sources are in Australia for employee entitlements, I'll hand over to James again to just go over what are some actual common causes of an underpayment from these sources. Thanks, James.
Yeah, so there can be many when it comes to what can actually cause the underpayment. In its essence, the underpayment just comes from failing to comply with any of those minimum entitlements that Joel's outlined. Number one, a very common one, is human error. So not every employer sets out to deliberately underpay their employees. Some do. The very vast majority, certainly the ones that we see, have never intended the underpayment. When it comes to human error, it can be something as simple as inputting data into a payroll software, piece of payroll software incorrectly. So whether that's been the actual hours that the employee has worked, so there's a discrepancy between what they've worked and what's gone into the payroll system. It could be something like what level the employee is under an award. So if there's an award which applies to your business, the employees are covered by that award, that's question one. You then need to figure out what level under that award the employee actually sits at. And now every level will have a corresponding pay rate. So you'll often see a level 1 employee is your more junior employee, they get a particular rate. Perhaps after a period of experience with the business or time passing, or they get new qualification, or they get higher duties, they might move to a level 2. And what comes with that is actually another wage increase. So an employer can simply put the wrong level in by mistake. They can also put the wrong rate in, so they can get the level right and they can get the rate wrong when they're setting up their payroll software, and they can have deficient payroll software. So very common for that to be an issue for businesses, and I suppose that human error comes into form. So yes, purely just inputting the data incorrectly, but also making a mistake when you're figuring out what that data is, and that's something which I would say is probably the most common basis for it. The third issue that we'll see is failing to comply with or understand the actual obligations in a particular award or an enterprise agreement. So the types of things that you'll see in a modern award might be additional entitlements to allowances or to loadings or to penalty rates. So the employees who are entitled to things like what is commonly time and a half on a Saturday, or double time on a Sunday, or double time on a public holiday, or a specific entitlement to time and a half or double time for overtime. Those entitlements come when there is a modern award. Now, every modern award follows a similar structure to what I've talked about there in terms of time and a half for overtime and penalty rates for Saturdays and Sundays and that type of thing, but they're all different. And they're all complicated. So it's common for employers just to simply not understand what the obligation is, and therefore not pay it. And that's why there's often unknowingly an ongoing liability when it comes to underpayment, because where these things have just not been understood, they just sort of continue perpetually. You see the same issues with enterprise agreements. Where you have an enterprise agreement, because that is something which applies specifically to your business, rather than say a modern award which is covering everyone in the industry or the occupation, you're more likely to have given thought to an enterprise agreement because you actually have to draft it and then ask the Fair Work Commission to approve it. So we see less issues in relation to people not understanding their enterprise agreements, but it's also very common for enterprise agreements to have been drafted in a fairly ambiguous way. And so there's often some argument to be had over whether particular entitlements under those agreements are actually owed. Another aspect that we see is missing annual updates to the award rates. So ordinarily, every year on 1 July, the Fair Work Commission releases a new minimum wage order. They increase the national minimum wage, and what they will also do is then make increases to all of the modern awards, and the particular rates within them. So recently, last 1 July, nearly every one of those 122 modern awards had a 2.5% increase to the rates within them. The Fair Work Commission does then, or the Ombudsman and Commission together, will actually send out a pay guide to let you know what the new rates are, but you need to be on that. and you need to be aware that once you've set your rates, that they may not be compliant forever, and they are subject to move. The Commission puts a lot of thought into whether or not they will increase those rates, but certainly for the last 10 years at least, we've seen them continue to go up, and maybe a bit of a delay in the increases for some industries. When COVID hit recently, the Commission didn't want to put too much pressure on businesses, but generally they're interested in pushing those increases every year. The final one that we see quite a lot is misusing annualised salaries. So the simple way for a lot of employers to deal with what is a very complicated modern award system is to just pay an employee an annualised salary, and to say, look, you know, maybe the award minimum is say a salary of $50,000 a year, but I'm happy to pay you $70,000. So let's provide you with a contract that pays you $70K a year, and we'll put a clause in there that says this $70K covers everything. Now, in that example, you've got a reasonable buffer, so that if the employee does actually have entitlements under that award, which go beyond what they would ordinarily be entitled to, so you know, the 50,000 under the award really just contemplates them working standard ordinary hours and not any, say, overtime or penalty rates or any, you know, particular allowances, you're going to be fine if they do work to those normal hours. Increasingly, what we see is employers putting an annualised salary in, thinking that covers everything, but then that employee ends up working a lot of extra overtime, or they might end up working Saturdays and Sundays. And as it turns out, the annualised salary which the employer has put in doesn't actually compensate them for all of their entitlements under the award. So you just get to a point where if we look at their hours of work and we apply the award to those hours, it ends up being more than the salary that you've paid them in that year, and we have an underpayment. It's as simple as that. So employers really need to think about where they are using annualised salaries, that number one, they've got a contract which is well drafted to make sure it is definitely covering all of those entitlements under the award. But number two, that it's actually set at a level which is high enough to compensate for everything. Unfortunately, what that means for a lot of employers is to keep quite a close eye on the actual hours of work, make sure they're across their record keeping, making sure the employees are not working more than what was expected when they set that salary. So a recent example of this is Woolworths. You might have heard about this one in the media, but Woolworths landed a $300 million underpayment in relation to their use of annualised salaries, where they basically set their managers with a salary, thought that would be enough. As it turns out, the salary wasn't enough to cover all of those award or maybe enterprise agreement entitlements. And that on scale over a period of 6 years, and when you're a business as big as Woolworths, that can certainly rack up pretty quickly. So, you know, they're a company that can handle that, but it's still not a drop in the ocean for them. It's a significant back payment for them to handle. So I want to move on to next now, and Joel will talk to us about, right, how do we actually conduct a wage audit. So what is the process for, we've understood now that, okay, there's probably a modern award covering my business, aspects of my business. Maybe we do have an enterprise agreement. We certainly should have everyone on employment contracts. We know that it's pretty easy for there to be an underpayment. A lot of businesses are carrying this liability. So what do we do about it? How do we get on the front foot and figure out whether or not we are compliant? So over to you, Joel.
Thanks, James. And as everyone can probably imagine, the necessary action to take in relation to a potential underpayment or approaching an audit generally needs to be determined by the individual circumstances. And there will be a large range in complexity and the approach taken based on factors such as the source of the entitlement, the relevant period of the potential underpayment, and the documentation available. And an example of this is that if we're just calculating an entitlement to annual leave and any related underpayment to that, where proper service records are kept, it will be quite easy to determine what the annual leave owing is. However, going to the other end of the scale, calculating entitlements under a modern award, where a number of loadings and penalties may apply, can be much more complex, especially where it relates to a significant period or where proper employment records haven't been kept. And the approach to an audit will also differ dependent on the way an underpayment is identified or the way the audit is commenced. And for example, an individual employee making a claim to a company directly may be a one-off issue, may be quite easy to resolve and not result in any other action after it's resolved. However, where a systemic issue is identified, this may call for a company-wide audit or a business unit audit to identify the related liabilities and ensure that legal risk is properly taken care of. And similarly, some employers will actually conduct wage audits of at least a sample of employees quite regularly, just as a best practice approach to identify issues before they get out of control effectively. And if you do identify an underpayment within your business and you're proactive in trying to address it, it gives you the opportunity to control the messaging around the issue, but it also is a relevant factor if, for example, there are later penalty proceedings relating to a contravention, because that proactive behaviour by the employer will be taken into account. And James and I have seen this in practice be quite significant with dealing with the FWO. They do absolutely want to see employers proactively addressing things. And where an audit is conducted, it will often commence with legal advice to identify the potentially relevant sources of entitlement. And then for more number-heavy, lengthy or complicated matters, an accountant will usually be used to crunch the numbers. And for particularly complicated issues, it's not uncommon for forensic accountants to be retained, because they're the number experts, not the lawyers, but you can imagine how it can be quite complicated going between a client, a lawyer, a forensic accountant, and any other involved parties. It does get quite difficult. And as James pointed out in his last little section, a really important point to remember is proper record keeping will often be necessary to be able to accurately calculate entitlements owed, including things like the hours worked and overtime records, absolutely vital. And this is obviously a good reason to keep records in and of itself, but it is worth noting that it is required under the Fair Work Act and the regulations regardless. And so every business should ensure they're complying with those obligations. Now, to demonstrate what a common audit process may look like, and again, this is quite general and it will have to be tailored to individual circumstances, the first step will be understanding the legal source of entitlements for the employee. For example, under a modern award, this may be minimum rates of pay under a certain classification, as well as allowances, penalties, loadings. And again, this is quite tricky. So this is the step that the lawyer is normally first involved and most importantly involved in. And then we'll go to step 2, which is to determine the minimum entitlement actually owed to the employee for the hours they have worked during the relevant period. And so this is to understand what the actual minimum legal entitlement is for the employee. And as James has said, people are often paid salaries or they're paid sporadic overtime or anything like that, but it's really important to understand what the absolute minimum legally owed to the employee is. And that's obviously one of the most important steps in this process. And then you move on to the next step, which is to determine how much the employee was actually paid during the relevant period. And at this point, you also look into, am I entitled to offset certain amounts paid to the employee for a certain purpose, such as a salary, against other entitlements, say under a modern award? And that is reliant on, properly having a contractual offset clause, which is very important in these circumstances where you're paying an annualized salary to employees. And then finally, you reach step 4 in what is a very oversimplified process here, but then you calculate the liability, which is the difference between what was legally owed to the employee and what the employer actually paid, subject to any offsets as well. Like as I've said a few times, this is quite a simple approach to audit, but it is reflective of what would need to be conducted in any real situation where there has been an underpayment identified. And so once you've identified an underpayment, obviously it's not great news, but what should you actually do? And luckily we have James here to tell us a bit about that.
So when it comes to what to do, I mean, firstly, you should talk to us. It goes without saying. This is something where we can actually provide you with real specialist advice on, because there is a lot of strategy It will depend on things like how many employees have been underpaid. So if you just have 1 or 2 employees and we have a type of underpayment which is quite accidental and maybe not a very significant quantum, we can handle this very casually, and you can sit down with that employee and say, whoops, sorry about that. We've just figured out that there was an issue and we've resolved it. Happy to chat. By contrast, and look at a process we've been through with a client recently who uncovered that they had underpaid 10 or 11,000 employees to the tune of several million in the underpayment. We took a very different approach, as you can imagine. So really it is a horses for courses type situation here. So we think about, well, what is the underpayment? How has it occurred? How much is the underpayment? The nature of the underpayment. So is this an obvious one? How has the underpayment actually been raised to us? So is it a situation where we've had a group of 50 employees come to us and say, look, we've all been to a lawyer ourselves and understand that we have all been underpaid and you've got 7 days to comply? Or is this something that we just stumbled across ourselves accidentally, or we might have carried out an internal audit and identified that we have some problems and now we're on the front foot? The primary concern is actually figuring out the liability and then focusing on remediation. There are almost no circumstances where it can be recommended to an employer who has identified an underpayment just to leave it and hope no one will find out. People will find out. Increasingly, employees are aware of this. There is so much media attention to it, and there are so many easy sort of avenues for employees to go and get advice on their situation, and sort of very limited cost barriers for them to do that, certainly in the initial phase anyway. So it's going to come out, which is why thinking about things like a communication strategy can be important. So that's both your internal strategy. So as part of the last project that we did, we prepared communications for the employer to send across. We did a 10,000 employees mail out, where we were able to actually identify to every single employee which section of the award we determined that there was a contravention of, and then exactly what the corresponding amount was for every single employee for 10,000 of them. So we had a nice little piece of software here internally which could merge all of that together into a letter. That made it very clear to the employees what they were dealing with, made it very clear to the employees that the company was quite sure of what the liability was. It also limits employees then turning around and saying, well, you didn't realise what you were doing the entire time, so why do I trust this back payment that you're telling me now? So that sort of clarity is really helpful for employees. You also want to think about your communication strategy externally. And again, you know, it depends on your business, depends on the quantum of the underpayment here, that whether or not you're going to get media attention is something you'll need to think about. But being prepared for that. That's why it's almost always best to be on the front foot with these underpayment issues. So do the audit yourself, find out before someone else does, and you can control this process. A very common question and a really, I suppose, key issue here is whether or not you tell the Fair Work Ombudsman. The Fair Work Ombudsman is the regulator of all of these industrial laws. They are the ones who will prosecute you, so they will bring a claim against you to say that you've breached the Fair Work Act or the award, and they will seek penalties against you, usually in the federal court, the Federal Circuit Court. So they are the ones we need to please in this situation sometimes. So there's a decision here about whether we go and confess, and we tell them that, yes, we've identified this, however, we've resolved it, or we've identified this, we're in the process of resolving it, and we'd be more than happy for you to be involved in the remediation of this. There are some obvious risks with associated with going to the Ombudsman, being the person who'll prosecute you for these, and that's obviously that they turn around and say, thanks for letting us know, we're now prosecuting you. But I think a point which Joel had mentioned previously is if we think long term with our strategy on these underpayment issues, and if we think that it's probably inevitable that the Ombudsman will find out one way or another, we'd like to be ordinarily heading off to court, being able to say, yes, there was an issue. As soon as we found out, we fixed it. And we were the ones who went and confessed, and therefore we accept that we're going to cop a penalty here from the court because we did the wrong thing, but we don't think it should be a significant one because ultimately this was accidental, and we've been good people in resolving it. So there's a lot of consideration on that call. There's obviously an extreme benefit on that penalty front if you've been the one to go and tell the Ombudsman. One of the options available, and you'll probably see there are an increasingly large number of these handed out by the Fair Work Ombudsman, is that as an alternative to them prosecuting you in court and as an alternative to them then seeking penalties against you, they do have an option whereby you can enter into what's called an enforceable undertaking. Effectively, that's an agreement between you and the Fair Work Ombudsman where you agree, well, firstly, you warrant that you fixed all the problems. You admit to what the problems were. You also then, if you haven't already, agree to remediate, so back pay, all of those types of things. You typically then also agree to a lot of steps you might take to ensure ongoing compliance. Usually lasts about 2 more years of what you'll do in the next, what you'll do in the next 2 years for compliance issues. So they may be things like, we'll make sure that we do audits every year from now on. We're going to agree to train all of our payroll and HR people about all of the obligations that they've got, as well as our managers as well within the business. What it can also include, and what it will increasingly include now that the Fair Work Ombudsman is probably a little less forgiving to employers these days than they may have been, 5 to 10 years ago, is that you may pay a contrition payment. It's usually going to be less than what you'd pay in court. But that's certainly something to factor in. So that question about do we go to the Fair Work Ombudsman or not, you are not obliged to. There's no law which says you have to, but there are a lot of benefits for doing so. So I think that probably wraps us up for today. We have some questions that have come through, which we'll talk about, and then and of course please send any through now if you have them. I hope that's been useful today for you, just basically understanding, well, okay, how do we identify underpayments? What actually are all of these entitlements which are frequently underpaid, and what to do. So if you are thinking about doing an audit in your business, or you have concerns about particular issues, you need advice on those modern awards and what your obligations are. You want to check any of your sort of processes and procedures in relation to employee management and issues, particularly in relation to wage, but obviously everything more broadly, then please do get in touch with us. I'm going to jump to the questions, and this one's I'll give to you, Joel. Can I include the annual leave loading amount within the salary and pay that as an annualised salary arrangement?
Yes, so we're probably just talking about an industrial instrument leave loading under an award or an EA. The answer is that if you have a proper contractual offset that specifically identifies and accounts for that leave loading, then yes, you can, just in your employment contract. There are also other arrangements around annualized salaries, sometimes within modern awards, that are separate to a common law offset that I've just described. And so that if you follow the award way of doing it, as opposed to the common law way, there may be some obligations around record keeping and audit that actually do apply as well. And so most of our clients do go through with that common law offset in their contract of employment, and that is applicable. It does cover the law.
All right, thank you, Joel. So the next one, and it looks like we just have 2 questions today, so we're near to wrapping up. there are any more, please do send them through. What if our organisation has an enterprise agreement with approximately 5% above the minimum wage? Are we required to apply minimum wage and superannuation increases? So we talked about earlier that it's quite common for businesses to miss out on these or to not realise that the modern award rate is increasing or the minimum wage is increasing every year. For this specific question, it really depends on what your enterprise agreement says. So if your enterprise agreement just has a particular wage, which rate in it, or payment rate in it, which happens to be 5% above the modern award at the moment, you wouldn't need to increase it because that rate is still above the award rate. And that effectively means that until the modern award rate goes above, and this is the base rate in the modern award, so until the base rate in the modern award goes above your enterprise agreement rate, you don't need to move your enterprise agreement rate. Once the modern award rate goes above the base rate in your enterprise agreement, you'll need to then increase those rates under the enterprise agreement. The time you might need to continue to move your rate up is if within that enterprise agreement it actually says that the rate you're entitled to is, say, 5% more than whatever's in the modern award. Then of course, if the modern award moves, so too does the rate in your enterprise agreement. So I hope that answers that one. Let's see. Yes, and I think the next question we've got, if our employees are on a collective agreement and paid above the modern award, do we have to apply the 2.5% increase? Yeah, so that's I think the same question there really. So yes, it really depends on the drafting of that enterprise agreement and then where your rates in the EA are sitting as against that modern award. So there will almost always be a time in the enterprise agreement's life when the modern award rate will supersede it or will surpass it, and that's when the rate needs to move. But that only applies in relation to the base rates. So we do see that a lot of employers who have particularly old enterprise agreements that their employees have not sought to terminate can be on some very beneficial terms as against the modern award, and those agreements continue to apply until someone terminates them. So often it's the case that if the employees did seek to have them terminated so that they could then be covered by just the award, the Fair Work Commission would almost certainly agree. But that's definitely a situation where employers are probably, the prudent thing to do is let sleeping dogs lie and not raise anything about that and stay on those rates. This one for you, Joel. Can we include allowances in the pay rate, for example, sorry, can we include allowances in the pay rate, for example, a travel allowance for a construction worker?
So that's a similar answer to that first question we had, that as long as you have that contractual term that specifically seeks to offset it. So you can't just pay a salary under the contract and say it notionally offsets against award entitlements. You need to specifically identify, and the way it's often addressed by employers, and this is what we advise as well, is just including a clause in the remuneration section that specifically accounts for all categories of award entitlement. So it actually lists things like this salary is intended to account for all allowances, loadings, penalties under any industrial instrument. So similar to that leave loading, yes, as long as you're contractually contemplating it specifically.
Thanks, Joel. We've got another one come through. Can we summarise the classification process? How can you ensure that you have the correct classification? That's a great question. The classification process, I'll talk you through how we would approach it. The first question is, do we have the correct modern award? Now, every modern award has a coverage clause. So it tells you who it applies to. And as Joel mentioned, an award can apply either in respect of an industry or an occupation. So for example, the retail industry award is going to cover employers in the retail industry, But the Clerical Employees Award is going to cover people who are in admin roles, no matter what industry they're in. So step number one is to look at the coverage clause. That in and of itself, it can be a complicated, I guess, question and something that we really need to work through to figure out, well, are we actually even in this particular industry? But the award will have definitions of what the industry is. Sometimes it has examples, more often than not, it doesn't. Number one, we figure out the coverage. So does the award actually then apply? The next step is to then actually think about the individual employee who we're thinking about. And so you'll jump down to what is most commonly in awards, Schedule B, which is the classification section, although it's changed a little bit now, but usually there's a schedule which deals with classifications. And this is where we'll have, I guess, a section which says, here are all the levels. So it might be level 1, 2, 3, 4, 5, and be simple. Some awards are simple like that. The miscellaneous award, for example, has 4 levels. So the process for that award is to then say, what does it say a level 1 employee does? And then we look at the position description or the duties of an employee, and we basically see, well, do they actually fit within that? We might look at it at level 1 and say, no, they're too senior for that. Let's look at level 2. Those levels, of course, they're not brilliantly drafted. They're often very frustratingly vague and say things like an employee at this level works with some autonomy. And unfortunately, it's left to employers to figure out what does some autonomy mean. Now, if there's an obvious fit, which there sometimes is, that's great. If you are running into extreme ambiguity, which is very common for people trying to figure out award coverage, you may then look to some decisions from the Fair Work Commission where they, for example, have, an employee has classified someone, the employee's challenged it, and the Fair Work Commission has actually made a ruling. If you're lucky, you'll find a ruling from the Fair Work Commission which explains that, this person in this business who was doing these types of duties is a level 3. And if that's the same setup to what's in your business, great, you'll have some certainty. More often than not, you just have to kind of survive in the grey area. It can frankly be helpful to have an opinion from us on this. If we say, yes, it's grey, but ultimately we think that employee is a level 2, and you go and pay them as a level 2, if it turns out that the Fair Work Commission later down the line disagrees with us, and the Fair Work Commission might think they're a level 3 who's entitled to more, well, number one, you can maybe sue us for the incorrect advice and recover your losses there. Don't do that, they could. But number 3, you're not going to be penalised by the Fair Work Commission for an underpayment where you are effectively acting on our advice, notwithstanding that it may have been incorrect. So I don't say that to make you lose confidence in our ability to advise on those things, but just to know that it is possible. There is a lot of grey area in these awards, and there's not actually a guarantee that the Fair Work Commission will agree with your view of their coverage or our view of their coverage. Sometimes to your benefit too. The Commission might actually think they're at a lower level than what you've been paying them, so it is helpful sometimes, but more often than not, you'll find that the Commission thinks the employer is entitled to more than what you do. So that's broadly the process. Like I said, it's easy if you've got only a couple of levels. If you look at something like the manufacturing industry award, it's a bit of a nightmare of an award. I think it's approximately 200 pages long. It doesn't have things like level 1, 2, 3, 4. It goes on to things like level A 1 to 15 and down to C, D 1 to 15. All sorts of different streams for different areas that you might be working in. So every award is different, but broadly, that is the process that you need to follow. I think that's all we've got for questions. So we might wrap up there. The only final thing that I wanted to add is basically in relation to an offer which we're making to all the attendees here for this webinar. We'll bring that up on the screen. in a minute. This is something you can make use of if you do have more questions that you haven't been able to submit now. Feel free to make use of this offer and to have a chat with us. But basically what we'd like to offer attendees of this webinar is complimentary, basically strategy session. We can discuss your employment law needs just more generally, not just in relation to underpayment, but certainly can chat about that. Otherwise also chat about the business, other things you might need to talk about. Legal Vision is a full service law firm, so while we spent today talking about employment, we can assist you in all aspects of your business. We're operating now on a membership basis, which is effectively a monthly fee, and that covers everything you could possibly need for your business or your BAU type inquiries. It's all unlimited. We'll handle all of that. So the other part of this offer here is that attendees will get a free month of that membership. And so look, click yes in the survey that comes after this, and we can get in touch with you to have that chat. We'll also share, more relevant to what we've talked about today, we've prepared a guide to preventing underpayment. It covers a lot of things we've talked about today. It gives you a little bit more information on things like modern awards and enterprise agreements and all of those allowances and loadings and all the other jargon which we've just thrown at you for the last 45 minutes. So you can take a bit of time to read through that. And of course, look, any further questions, these are certainly things we're happy to assist your business with. So please do reach out, and otherwise, thanks for your attendance today and all your questions. We'll see you next time.
Thanks, everyone.